One.
Great, got it. Hi, everybody. My introduction is that I'm a litigator. I graduated in 2017, and I work with two lawyers. One of them is called Gopal Shankar Narayanan. The other is called Haripriya Padmanabhan. They work out of the same office, and I work on both their matters. Primarily, my work is at the Supreme Court, sometimes at the High Court. When I say my work, I mean my work with them. Recently, I've started doing some of my own matters, which are at the CAT, which is the Central Administrative Tribunal. Some of you might know it. It's basically a forum for service law matters. And apart from that, other cases are at the High Court and Supreme Court. Now, as Saurabh sir mentioned, my profile is, I like to call myself a litigator who has one foot in academia, and I desperately try to maintain that position, mostly because I feel that litigation often takes away some intellectual honesty from you, and there's not always enough space to honestly and sincerely approach a legal problem as you'd like to, because you're bound by your client's position on an issue. So that's the broad idea. That's why I'm also dangling in academia. Today's session, I understand, is mostly so that I can speak to you about why data is important to somebody who practices in court. The answer is sort of intuitive to me, and it's difficult to immediately, put it into words and articulate it. So what I'm going to do is I'm going to use some examples from what I've seen over the past 4 years at the Supreme Court, and how I felt that the use of data was path-breaking in a particular case, and how it could have helped in a particular case but didn't, etc., etc. And now, my understanding is that I'm sure that data is used by litigators for a variety of reasons, but I'd like to think of it in broadly two categories, and that's the framework I'm going to be discussing this in. The first kind of use of data is when you're using it as part of your case, in the sense that part of your argument is based on some kind of data. So this could be that, you could be trying to convince the court that you should take a particular position because this position has been taken so many times in the past, or that this kind of remedy is a very rare remedy. It's so rare that it's granted only in X percentage of cases, as history shows us. Something like that. That's the first category of, that's the first kind of use of data by a litigator. And the second kind, which I have frequently seen, is use in terms of strategy to understand how and where the case is going to go. So you might have heard a lot of lawyers say that really the outcome of a case depends on the judge. So before knowing the case, you should know the judge and this and that. So the idea is judges have their own proclivities about entertaining particular kinds of matters. And this is all a very regular part of corridor gossip in the Supreme Court and High Court, and basically all courts. This judge is like that judge is like that. Or if it's a writ petition concerning fundamental rights, that judge is likely to hear it. Or the other judge is likely to send you back to the High Court. That person doesn't like Article 32 petition, so on and so forth. So the idea is these are two ways in which I've seen litigators engage with data on a day-to-day basis. Some of these areas are more accessible to litigators and some are not. And let me just deep dive into these two categories to explain what I mean. The first is, and I don't know what the format is usually, but I'd be open to questions being asked even in between, as in I don't mind being interrupted. In fact, that makes for a better conversation. So the first is use of data as part of argument. Now, to understand this, at least the way I see it is, the Supreme Court and all other courts have always maintained that stare decisis is a big virtue for them. Stare decisis, as you might know, is a Latin phrase which means let the decision stand. This is basically a system of precedent, which means if the court has taken a particular position in a particular case at one time, in future, similar cases, the court will take similar positions. It will not steer away from those positions. So because this value is so dearly held by all courts in the country, which is the value of stare decisis, that we will follow our precedent. Litigation is mostly about, it's a lot about the facts of the case also, but when it comes to the law, it's mostly about finding the right precedent and showing it to the court. But often the mistake that litigators make, in my view, most litigators, is that they limit their research of precedent, research of case law, only to finding that one case, that one relevant clinching judgment which applies to their case, which has similar facts, and boom, they think that's the end of story. Often that doesn't work because, the idea behind stare decisis, as you might know, is basically an idea of equality, that we will not treat similarly placed litigants differently. So even if we got it wrong the first time, we are going to apply the same judgment the second time around, because there is some value in equality itself. And we don't want to give out the perception that we are biased towards one kind of litigants, etc. That's why the court maintains this value of stare decisis. And for the same reason, the moment you cite a judgment which you think is clinching, the court has the option of distinguishing it on facts and saying, we don't think that litigant was similarly placed because of this difference in the facts of that case. And the moment the judge says that, your precedent is out of the window. Now, the reason why I think this is a mistake, obviously this is something that you have to do. You can't not do this, but there is something else that litigators can do, which they don't mostly, which is presenting research or data or empirical information about their precedents rather than just showing them precedents. So I'll just explain an example, this with an example. In one of my earliest cases with Mr. Shankar Narayanan, we were dealing with a quo warranto petition that was filed against our client. Now, a quo warranto petition, for those who are uninitiated, a quo warranto is one of the writs that the Supreme Court and the High Courts have the power to issue. It means somebody has occupied a very significant public post without having the minimum qualifications for that post. And somebody has filed this petition in the court asking for that person to be removed from this significant public post. Now, we kept hearing, and we kept hearing means that judgments after judgment kept repeating the fact that quo warranto is a very rare remedy. It's an exceptional remedy that the court will not ordinarily grant. They'll only grant it if the public post in question is really significant. Not for your usual departments, MCD, this, that, nothing. Only if it's a really significant constitutional post. One of the examples is Jayalalitha's case. And she was, of course, the chief minister. So the idea was always clear to us, but how exceptional is this remedy in terms of statistics? That was a question that was till now unanswered. And Gopal sir just comes to me one day and says, I want you to go through all quo warranto cases. And at first I thought this was a joke. Obviously I can't go through all of them. What he means is I have to go through the past 20 years of the Supreme Court, this and that. He said, no, since 1950, since when the Supreme Court was established, you have to read every single quo warranto case that's been there. I want you to find out the number of cases that were totally filed and the number of cases in which the writ was actually issued by the Supreme Court. And this is, initially I thought this is wacky. Why should I be doing this? But towards the end of the exercise, the figures were such that at least my research showed that it was only in 10 cases in the past 70 years of the Supreme Court's history and my sample size was basically all the cases that are reported judgments. So this is not the entire sample size, but quite representative. The idea was, only 10 cases in the past 70 years where Supreme Court has actually issued the writ. And when we told this to our senior advocate who was arguing the case for us, that argument was just something else in court. It is one thing to say to the bench that, this is a very exceptional remedy. Look, this precedent, this case law says that it is an exceptional remedy not to be usually granted. But parroting this statement is much weaker than telling them this is how exceptional it is. 70 years, 10 times is really less. For a court that is exploding with cases every day. And one could immediately see the impact that it had on the bench. And really, I think that was my first exposure to how empirical research can be used to build an argument in court, a substantive argument, not just some random references during arguments, but really this was the core of what we were submitting to the bench. So that's one way in which you could use it. Another example, which is very recent, so it's fresh in my memory. You might have read in one of these legal blogs that in the Maratha reservations case, the Supreme Court was faced with the question as to whether the judgment in Indra Sani was the 9-judge bench decision from 1992, the Mandal Commission case. So in the Maratha case, the Supreme Court was considering whether that 9-judge has to be revisited. Is it wrongly decided? And what part of it? You might know that that 9-judge bench had, in 1992, had said reservations granted to backward classes cannot cross 50% of the total seats or posts or whatever the unit is in any given year. So if you have 100 seats, only 50 can be reserved. The other 50 have to be open for the general category, that is the open category. Now, the question was, does this have to be revisited? And now, the argument that was being made by us and other lawyers on our side, we didn't want it revisited. We wanted Indra Sani to stay. So we told the bench, look, the other lawyers on our side told the bench that, look, stare decisis, it's precedent, it's 9 judges, it's been followed for so many years now. But again, this argument that it has been followed for so many years, just saying it in words is not as impactful as showing them how often it has been followed. And so now again, I was given the task to follow Indra Sani and find out every single reported judgment since 1992 where Indra Sani was followed. And also, sir told me, write down the names of the judges who followed it. So it's not just the fact that it's been followed, but who all have followed it. The various hues and regions from which the judges come, their own backgrounds in terms of caste and religion, which is not something that you expressly say in court, but it's visible. The diversity of the people who have upheld it is immediately visible. So by the end of it, sir submitted this table, which had around 70 cases, which I had been able to find. All of them, again, the sample size was the same, reported cases on SCC Online. And funnily, the table had the names of every single of the 5 judges who were hearing the Maratha case. And it's, fascinating to say that, it's been followed, so please don't disturb it, one thing. But to say every single one of you sitting in some bench in some other case have followed and applied Indra Sani specifically on the 50% limit. That's a completely different argument that's driven by data. And it's quite fascinating to see that so many other people will just get up and make the same argument again and again, which is only doctrinal in nature. And this one, Gopal sir is often the youngest senior advocate to be arguing these cases. And he stands up and only hands over a table. That's all. A 1-page or a 2-page table, which has names of judges, cases, citations, is there. And it's so impactful that you could immediately see all judges nodding in agreement. And I think the judgment is unanimous on the point that Indra Sani doesn't have to be referred. So those are some experiences that have led me to believe that this is a good way of litigating. You shouldn't just rely on propositions from case law, but also try to cull out some statistics of how the court behaves, which sort of tells you the mood of the court, the currents that is flowing, and the subtler things like that, which really have an impact on the bench.
That was mind-blowing, to say the least. I think like these 2-3 examples that you shared, Shrutanjaya, was like, I don't have that perspective, so at least I was like super impressed, and it just gave me a very new view to how people think about like arguing their case. Guys, any question? Yeah, Varun, you can unmute yourself and ask the question.
Hi, am I audible?
Hi, yeah.
Hi, Shrutanjaya. Thank you for coming and talking to us. I've been following your work. I read the habeas corpus paper last year, and after that, I wanted to do my own research about how habeas corpus was dealt in Jammu and Kashmir High Court specifically. and I wanted to map how they've been dealing with these kinds of petitions before 2019 when Article 370 was abrogated, and after 2019. So I found that in 2019, the least number of cases were disposed, habeas corpus cases were disposed when the highest petitions were filed. Now I got this data from by filing an RTI, but generally also I've been trying to find this data, and I wanted to ask you one question about sources. Like, how do you go about finding this kind of data? Like, I know you refer to SEC online, but can you refer to Indian Qanun? And also there's a national judicial data grid. If you know about it, what are your opinions about it? If you can use the data available there. That's my one question. And another question I wanted to ask was, when I was reading habeas corpus petitions in Jammu Kashmir High Court specifically, most of the cases were of Public Safety Act. But so, like, I found a case where the petition was closed by saying closed as settled. Like, it was settled between the state and the accused. Like, I didn't understand. So, have you found these kinds of peculiar circumstances when you read those judgments in the judgments of habeas corpus judgments in the Supreme Court? So I was just wondering what are your observations about those cases?
Yeah, thanks. No, I'll first answer the second question, which is a shorter answer. No, I have never seen a line which says the case has been settled. But my first guess is, I mean, the only reasonable uh, circumstance in which the court could say this is where the détenu has been released. In that sense, if it's settled, then yeah, the petition is meaningless. But if it means anything else, then I'm quite taken aback. So I don't know.
Even if the détenu is released, shouldn't the court rule on the legality of the detention ideally?
In most cases, when the détenu is released, it is seen that the détenu's lawyer will come to court and say, I don't want to press the petition because there's no point because I've been released. In legal language, we say the petition is rendered infructuous, which is to say the relief that was sought is already granted. And in constitutional law cases, the Supreme Court has repeatedly laid down one principle, which is we will not unnecessarily pronounce on questions that touch upon constitutional law, specifically on liberties and preventive detention laws and trying to interpret them on Article 21. They'll avoid it if the facts don't necessarily demand that kind of an inquiry. That's what they say. So that's the instinct that possibly drives the court's actions in dismissing the petition. So maybe, but if it's anything else, like if there's a settlement that I will not press for my liberty in court, even though I'm not released, that would be very strange, and I'd really like to know if that's the case. But coming to your other question, yes, I think you should use whatever you have, with the only caveat that you have to ensure that the data is represented. Now, like I was telling Saurabh sir the other day, that habeas corpus paper that you refer to, after it was published, etc., I basically am waiting for the COVID situation to subside, which I don't think is happening anytime soon. But I think the ideal way to go about this, which is actually the traditional way in which people used to do research, is to go to the Supreme Court, sit down with the registry staff, and just ask them and be polite with them, be friends with them, whatever, and get them to share that computer screen with you for some time. And this is, I mean, it's unfortunate that you have to do it this way, that you have to make friends with them, this and that. Actually, it is a right, in my view, under the RTI Act, if it's read in the proper spirit, because the court authorities are supposed to make this information available to you on their own. But I mean, it's unfortunate that they don't. And right now, they will just say, COVID hai, baad mein aana, this and that. So right now, there's no point. But ideally, I think that should be the way forward. If not available, then I would say you should try and look for a source that systematically collects cases with a definition, as in you can easily know which are the cases that have been collected and which are the cases which have not been collected. So for example, with SEC Online, you know that they collect cases which the court itself says, yes, please report them, with a few exceptions. SEC Online often reports some non-reportable orders also, if it feels that they're important, but more or less, if the court says reportable, SEC Online will report it. Likewise with other reporters. Indian Qanun is, I think, less predictable, but their database is, I think, much wider because they don't have this filter. So they will keep reporting any and every judgment that they think is important. I don't think they use a reportable filter. National Judicial Data Grid, I think, is the only sort of exhaustive resource that you can have, because their idea is whatever cases there are, we are going to upload them. I don't know how much progress has been made. I think some of my friends were telling me that in some areas, some particular kinds of data, there's some trouble accessing it on the data grid. But more or less, the idea is every single order of a particular kind of case is going to be recorded. So really, that's the exhaustive research that you're looking at. Either you go sit with the Supreme Court registry or other courts, or you use the data grid. Unfortunately, we don't have something similar to the data grid for the Supreme Court. But I think the latest draft of the vision document that Justice Chandrachud had shared, that plans to put in place some kind of a similar mechanism. And I mean, the Supreme Court website at present is atrocious. It's really bad for researchers, unless you're
to navigate.
Yeah, and if you're planning to do it using Python or some other automating software, that's going to be good. If you can get past the CAPTCHA and everything, I'm sure it's possible. So, but other than that, I think it's a tough website to crack. Yeah.
I just have one follow-up question. So I got different numbers through RTI and through the data grid. What could be the reason for that discrepancy?
What's the difference? Which one is more and which one is less?
The RTI is substantially less than the grid, or maybe I'm operating the grid wrong because it's a little difficult to operate. But the way I did it, I was getting different numbers in the grid, and I got different numbers from the RTI.
To file another RTI and say, attach your data grid screenshot and say, please tell me the reason why your numbers are false or something like that. Try to frame it in a way that they can't tell you records are not available. Try to frame the question in a way that they can't avoid. But I mean, that's your best bet, I suppose, until you have access physically to the court records, or you can go through every single of the records on the grid. Maybe there's duplication. I don't know. I mean, just to give the government some benefit of doubt.
Thank you.
If there is duplication, then I don't know, but yeah.
Thank you.
You're welcome.
Shrutanjaya, I think there are two questions on the chat. The first one is, do you see any possibility for having a mathematical model which can predict judges' decision in a particular case based on the past record? That's question number one. The question number two, Smita, do you want to talk about specific case, like after Shrutanjaya has answered the first question? Yeah, maybe the first one, Shrutanjaya, you can answer.
Okay. Yeah. No, it's a fascinating idea. My intuitive sort of idea is it may not be possible because of how fact dependent every inquiry is. I think some kind of a mathematical prediction is possible and plausible, which is the proclivity of a judge in entertaining certain kinds of petitions. So just to give you an example, that was in fact the second head I was going to talk about. Professor Nick Robinson's research has really, I mean, shown us how rare the SLP remedy is supposed to be. For those of you who don't know, Article 136 of the Constitution says that in exceptional, it doesn't say exceptional, but the idea is in exceptional circumstances, the Supreme Court can grant a special permission to anybody to appeal against any judgment of the country given by any court in the country. So the idea is it's supposed to be exceptional. There's no right to appeal that's granted to anybody. It's a special discretion conferred on the court. Now, understandably, as Professor Robinson has shown us, 90% of these SLPs are dismissed on the first day, 90 or 95% perhaps. What happens to the remaining ones? That's the question. Now, I mean, it's one thing to say, okay, 90 to 95 are dismissed and the rest are admitted. But can there be, and I think there can be perhaps, a more granular analysis of which judge is more inclined to allow special leave petitions and which judge is not? So you have some judges which are very famous for being very negative. Negative is the word that is used in the corridors, that they are against petitioners because they staunchly believe that Article 136 should be curbed. SLPs should be less admitted. The Supreme Court's role is more to protect fundamental rights, not to hear these property disputes or shareholder agreement disputes, this and that. So those judges are more likely to dismiss. Now we know this because we have felt this in our experiences. Some judges are just, why are you here, this, that, and they dismiss it. Some others are much more patient and they read the brief and come and they think, yeah, there's some merit and they allow. So, but it is one thing to feel it this way without any statistics, but quite another. It'd be very fascinating to see on a real-time updation basis. You know, I think it's possible because you have daily orders uploaded on the Supreme Court's website every day. So just to teach your program that, you know, you just have to tell me which judge is dismissing how many petitions out of how many on a given day. It'd be fascinating to see within those 5% that are admitted, which judge falls on which side of the line. And that, I think, will be a very significant part of any litigator strategy. I mean, you could sell it, I think, for lakhs of rupees. Anybody would buy it. It's that that kind of stuff. But yeah, I think that level of prediction is possible in specific cases.
Fascinating.
Just one bit of follow-up. I still think that it is possible in particular kinds of cases which relate to, say, specific laws. For instance, with the UAPA, for instance, you could have a model which predicts that, you know, this judge is more likely to give you bail, or this particular judge may not be inclined towards delivering a favorable verdict in the favor of the accused, something like that, right? So in these very particular cases involving very particular legislations, do you see any sort of possibility of this?
Yeah, I don't want to immediately say no. I mean, I think it's very tough to come up with a program that, I mean, I say it's tough because, again, it's really dependent on the facts of the case, and these judges are just too invested sometimes in the procedure that is followed, rather than the actual application of the UAPA, actually what the words mean, whether the person is entitled to bail, this and that. Often they're just fixated on the procedure that was followed by the state. And you'll see that sometimes bail is granted because procedure was not followed. Sometimes it's granted or sometimes it's not granted because even though I mean, it looks like this is a wrong case and it's a false case against the accused's conduct has been terrible. And those factors are just, I mean, I say sometimes, but I don't mean to put it in a statistical way. I don't know if it's the majority of, it may even be the majority of cases that extraneous factors like these, like the procedural ones, or like the accused behaving in a very shady manner, despite not being guilty at all. All of these factors influence the outcome of bail matters. But yes, I don't want to immediately shut out the idea. I think I'd be very interested in knowing the kind of steps that are put in the program that analyzes.
Yeah, and I think one of the fundamental challenges in some of these stuff is just the availability of data to train some of your machine learning or AI models if you were to do that kind of prediction. But like hopefully, like you know, we would reach there sooner than later. Smita, do you want to unmute yourself and ask the question?
Yeah, sure. Hi, Shrutanjaya. Thank you so much for talking to us today. I had one question which actually really bothers me a lot, and something that I've discussed before with my peers also is that SEC Online and Manupatra and all the other LexisNexis and other databases that we have, they're all paid subscriptions. So people who might not have access to those have access to like Indian Qanun, or they can file RTIs or stuff like that. But do you not think that there should be some other, you know, accessible resource that we as lawyers or we as citizens should or need to have? And if yes, then maybe there's something that I do not know. So if you could maybe throw some light on that. And in that vein, you were mentioning earlier in during your talk that there are some cases which are not reported at all. And SEC Online, which is the biggest, I think, resource that everybody refers to, they don't even report those, obviously. So how do we go around that? Like, why are some cases not reported at all? Like, I'm not very sure of that in the first place.
Yeah, no, so I'll just immediately answer the last bit first. The court itself decides whether this particular judgment will be reportable or not. When they say it's reportable, they actually, it's quite a misnomer. When they say reportable, it means it must be reported. It has to be, not that it can be, which is what your reportable would usually signify. But non-reportable means you have the discretion. So it is only in cases where the Supreme Court feels or any court feels that we have laid down something new about the law, or we have given a proposition that is important enough to be reiterated, even though it's settled before, but we think it's important to reiterate it. Those are the cases where usually the court says, okay, reportable. So HCC will automatically, mechanically pull those up and publish them. The others are discretionary. Sometimes some well-meaning lawyers will just send that order across to SEC online and say, please just report this. This is quite significant, even though it's just an order. So, I mean, the idea is mostly that the important legal issues, if they're covered in a judgment, reportable or non-reportable. But yes, I think I don't have any answer to the other part of the question, which is what do we do if we don't have access to these resources? Yes, it sucks that it's all paid. The idea is, I mean, they're all running business models. Their idea is we want to make money out of it. I think, I mean, it would be great if we had something like a search feature in the Supreme Court website, which was not the ridiculous search feature you have now, where you can't really cull out anything from the order. You just have to search for one word, and that's all you can do. But something which is more advanced and gives you the ability to search for put a Boolean search perhaps. But no, apart from that wishful thinking, I don't think there's any solution to this. Really. Indian Qanun, as I said, you can use it because it's the only sort of available resource. You just have to be careful in every particular research that you're doing that the sample that you're using is representative enough. And it's not, I mean, often you'll find that people will criticize you or your research only because it's Indian Qanun. And mostly because I think a couple of courts have also passed orders saying, what is this? Why do you get judgments from Indian Qanun? So their general credibility in academic circles and legal circles. Yeah, but I think, I mean, as long as you can defend it on robust logic, it should be fine. Like you don't have to, you can say that, yeah, maybe there are a couple of mistakes here and there, but largely my statistics can't be, I mean, they can't be way off. That's the point. But yeah, I think that compromise will have to be made.
Awesome.
Right.
Ashna, do you want to unmute yourself and ask the question? Ashna, are you there? You're on mute, Ashna. I think there's some issue with my mic. Not a problem. I think apart from COVID, the world is also facing a lot of like Zoom and Hangout issues. But crazy. Anyone else? Any other question? Or Ashna, you can just like type your question and I can ask it for you if that works. But in the meantime, I mean, while Shrutanjaya, you were speaking about like okay, actually Ashna is entering again. Maybe I'll just like wait for her to ask the question. Just 1 second.
Hi.
Hi Ashna. Yeah, please go ahead. Go ahead. Yeah, you are.
Yeah, thanks Shrutanjaya for all the information. So I was just wondering if you could maybe tell us a little about how empirical, like published empirical research can be used to sort of challenge, say, controversial matters that haven't been challenged so far. So for example, like long-standing precedent. So I think I'll give you an example sort of to help you understand why I'm asking this question. It's that, say, where judicial opinion, for instance, in death penalty cases plays a very significant role in determining outcomes, and the data itself is on judicial behavior, where there is empirical research to say that judges have, say, not adhered to what Bachchan Singh has laid down, etc., and that they are influenced by irrelevant sentencing factors and so on. So if there is actual published data or empirical research on that matter, and such challenges have never been made, how would you suggest that lawyers engage the court with such data? Yeah.
I think it's a very interesting question and something that I've also thought about a lot. I think specifically with the death penalty example, I think it's only a matter of time that a challenge is filed. When the last challenge to the death penalty was heard substantively, I think it was one judgment after review, after Bachchan Singh, that attempted to do it, but I mean, the council attempted to do it, but the court just refused it. So it's going to be effectively the first time that after the 1980s that the Supreme Court looks at it, the moment it's filed. And I think it will be really strong evidence towards the arbitrariness of the punishment, the data that's already been collected by these research centers. The only
drawback that I usually, sorry, this.
You are audible and you are, yeah, and it's much clearer than it was.
Sorry, one second.
Shrutanjaya, can you hear us? You are audible. I think Shrutanjaya will just join us in a minute.
Can you hear me?
Yes, yes, we can hear you.
Okay, I think my headphones ran out of battery. Where did you lose me?
I mean, I remember you said that this is something that you have thought about very deeply yourself.
Okay, no. So basically, I'm saying I think the data will play a key role in deciding the question of constitutional validity of the death penalty whenever the challenge is laid. And I think it's only a matter of time that such a challenge is laid. My own sense is that whoever is leading the research in various places must be waiting for the right moment in terms of the right environment, the right judges, and the other strategy considerations that apply in litigation. But yes, I think it's data is quite robust evidence in that kind of a situation. My only reservation is, and this is not something that may apply in the death penalty case because the data is so clinching, but in cases where data is not immediately clinching and not already collated by academia, in those cases, I feel a bit hesitant about it because, I mean, the first case that comes to mind is the 377 case from 2013, where the Supreme Court was too quick to say minuscule minority. You don't want to tell the court, especially if it's a judge that you're not sure about. You don't want to tell the judge that, it's only 0.so much % of cases where conviction has happened in 377. And those were the statistics, I think, that was presented before the court. I don't know if they were accurate. I don't know what the sample size was. The Supreme Court didn't care about sharing any of those details with us, but it just went on to say minuscule minority and well. So the statistics can go either way in some cases. So we just have to be careful of that. But yes, more or less, I think I'm in full agreement with you. I think data is sometimes really a good tool and should be used. I think like in cases like bail and UAPA and NDPS, where they make bail so difficult, it's surprising to me that litigators don't use data in mounting constitutional challenges. And on the corporate side of things, it's a bit surprising to me when challenges are filed to the insolvency code, for example. Immediately you see data after data, this percentage of insolvency resolutions have failed. And it's clear that people with resources have really thought about putting those resources to good use. So, I mean, it's also fascinating to see which cases end up using data and which ones don't. But yeah, I completely agree with you. Data should be used.
Yeah, I think like financial data is also much cleanly available in that sense for us to like. Smita, yeah, please go ahead. Ask your question.
Hi, it's just actually an afterthought on what Shreyas had said about using AI or like a mathematical code to understand the the views that judges take. So in light of your answer right now to what Ashna said, do you not think that using data to maybe categorize or pigeonhole or generalize some judges as favoring one particular aspect is also propagating following stereotypes? Because like you said, that it needs to be something that's flexible based on the circumstances, and it obviously data and law has to grow, right? So I think in an evolving society, maybe that kind of data set might actually have an opposite impact, essentially, especially because it would be used mostly in informal groups, like lawyers or litigators might use it to understand अच्छा किस judge के सामने case लगवाएं, or something like that, because since it won't be very comprehensive data sets, it might not be used officially. So what do you think about the like the bad side of it?
No, I'll just request you to repeat one aspect of your question. Why do you say it could be potentially harmful using the kind of data that this judge is more inclined to give the death penalty and this judge is more liberal, etc.? What's the harm?
Because what if like the judge wants to change his or her perception, and they want to go back on what they'd said in a previous judgment, or like you said, like in the reservation case, you told them that you were the ones who had already said that Indira Sahani should be followed, but what if they don't want to follow right now? So does that like maybe put like an informal like bar on them? It's just human psychology.
Yeah, no, I think that's fascinating.
I'm sorry to cut you off. Yeah, one additional thought. Isn't this also very, very related to the entire debate around AI as judges? Like that entire debate that everybody's having these days. So I think they are two things very closely related. And I don't know. I never seem to be able to wrap my head around it.
Yeah, no, I agree. I think often what the mistake that lawyers make is they do all of their research, whether it's empirical or doctrinal, all by themselves. They don't take the help of other disciplines. And psychology, I think, is an area that keeps cropping up in almost every second debate that you have. But yes, I completely agree. It could go either way. But it's just that what seems plausible to me now, based on nothing I know about psychology, is that judges are more likely to stick to their view only because of the subtle embarrassment that it brings. If you tell
Exactly.
5 judges on the bench, yeah, in the sense that if you tell 5 judges, look, you've just taken this view throughout, they'll try to not change that view. But like you said, yeah, it can sort of backfire in cases like the death penalty, where you want a judge to change their view. And yeah, I suppose you just don't show that data to the judge, and you try to convince them otherwise, or you try to ensure that your case doesn't sort of get listed before that judge. That's a bit tricky, but yeah, yeah, I see your point. I don't know how to sort of resolve this one way or the other.
Right. I think what might be interesting is seeing if this model is being followed like in other jurisdictions, and see what roadblocks they've come up with. I actually don't know. I'll read that up. Yeah.
Yeah. I don't know. Yeah.
I was speaking to someone who works in AI a few days back, and we were just discussing, like, on one hand, people are scared that AIs will come and like take away the job. On the other hand, my TV doesn't work that well either, right? Like so just that. And Smita, if I could add my 2 cents to that, I think there are 2 very key challenges to the whole AI judge. Like, AI engineers or anyone who are basically like working on AI technology, they don't think about automating a job. A job is made of like multiple smaller tasks, and AI right now is at a stage where some of those tasks can be automated in that sense. So definitely, like, it's a fascinating area to think about, like what AI judges would look like in future and things like that. My sense is that mostly it's possible in procedural matters, and not so much like where as Shrutanjaya said, like there are much wider complications than that. But yeah, I think like future is very exciting for law and justice, both in terms of like AI and litigation, and I'm very excited to see like what it holds for all of us. Any other question, anyone?
I just had one. Oh, okay.
Okay,
Sorry.
yeah, go ahead. No, Ashna, you go ahead and then I'll ask.
Okay. No, so I think my question is also based on the fact that there is research, I think, from the US, where judges have consistently, despite there being like so much empirical research to suggest that the death penalty is arbitrary, where they've consistently refused to use the data, and they've offered a lot of justifications like, oh, society needs this, or the community is not ready to abolish it, and etc., to convince, I think, others and themselves that the death penalty is required or something. So I think that's why it's really when, like Smita was saying, right, you put the judges in a tough spot and they are the ones who are being criticized of not following precedent. How far will they really change their minds? And just a small question that often I thought of during like forensic science classes was, in forensic cases, right? Because outcomes may hinge on like microscopic evidence, and forensic data is often not easily comprehensible by people who don't have specific training. So there is a lot of like scholarly research that says, we should push judges to understand or interpret forensic data. But really, how far can we engage judges with forensic data, given how complex it is? Like, do you think that there's a way to bring in forensic data into court without having, say, experts from other fields, or like how would you suggest that is possible?
No. I think that's also what you were suggesting. I think it's highly arrogant for all of us to think that judges will understand. I mean, and highly arrogant for judges to think that we are going to navigate through all aspects of science and we don't need any other experts. I think we should really know when the sphere of the law ends and where the sphere of our sense of fairness and justice and all this completely ends, and we have to hand over all responsibility to experts, like you said. So I think no, it's tough for me to think that judges will be so well versed with it, especially because they're damn busy. All the time you see judges grappling with 60 files for a day. I mean, the Supreme Court is absolutely insane. If you just see the number of matters that are listed on one Monday in regular court, and not these days, but when the court resumes again, every Monday, every Friday, you'll see every courtroom having 60 cases. Every courtroom. I mean, it's crazy. How do you expect those judges to be able to read those 60 files the previous day? I don't get it. I mean, their law clerks do it. Everybody has 2 or 3 law clerks, and they expect the law clerks to be able to wade through those 60, 70 briefs. 1 or 2 of those briefs will be perhaps death penalty matters, which will require consideration by 3 judges. So it's basically, I mean, the odds are better that somebody will be able to spot the key areas and the areas which are complex. But I mean, I don't expect people to be able to be on top of these complex things about forensic evidence and even, I mean, the standard, what do you call them, FSL reports and whatnot, that are very standard in criminal law, which in most cases are not even really closely analyzed. But it's just analysis of a very simple description written by a doctor or a chemical examiner or somebody in the impugned judgment that you just have to read and interpret. And sometimes judges get it so wrong. It's that basic that if I today just sit with that information and just type it on Google, 5 credible websites, including the national health websites of 5 different countries, will tell me what it means. But the judge will get it totally wrong. And it's this basic research that, and I don't believe that they tried to find it and they didn't find it. I think they didn't try to find it. They thought that they already know the answer, or their clerks thought that they already know the answer, and some mess up happened. So it's not, I mean, it's something that we should immediately give up, in my view, and judges should take help from experts. Just the other thing about death penalty that you mentioned, that's my reservation against statistics also, because in the US Supreme Court, the debate on the death penalty is not really about statistics, the way I see it and the way the other camp sees it. The camp that you refer to as judges who will just not strike down the death penalty despite the statistics, because they believe that the statistics don't matter. The arbitrariness of it doesn't matter. Because unlike the Indian Constitution, where arbitrariness is immediately a trigger word to invoke Article 14, in the US, they just don't have this understanding of the Equal Protection Clause. And they don't have this understanding of the due process clause, which says that you can't take away liberty or life without due process of law. Their understanding is, no, it's in our country, it's going to be only those traditional liberties which we have always preserved since centuries and stuff like that. Which is why the abortion debate is particularly murky, because it was obviously not something that was the right to abortion was obviously not something that was protected since ages. So there, I mean, we don't know if it's actually they are being honest about the defense that they're giving. This is not about statistics. It's about the other values that we preserve. It's our tradition, this and that. So if any change has to come, it has to come from the people, even if it is arbitrary. I think that's the argument there. So, I mean, I think these statistics stop being relevant after a point when they hit a roadblock in legal doctrine. But so I think it's just important for us to be able to spot that roadblock immediately. And then we have to work around it, basically. We can't, within the legal system.
Got it. Thank you. Thanks for that.
Shrutanjaya, you had started to say something and then.
Yeah, no, I forgot. I think it was related to something that Smita had said, but I forgot now. It's okay. I think it's covered.
AI, law, criminal justice, anything on that sort?
Oh, yeah. No, I was just, correct. I was thinking that maybe it'd be fascinating to build a system of bail, for example, just thinking out loud, where the default input in the program is you shall always grant bail. And the only circumstance when you will not grant bail is when A, B, C conditions are satisfied by the state. And that's usually the rule. I mean, Krishna here died saying this again and again, that, you know, bail is the rule, jail is the exception, this and that. So to implement it, and I don't know if there is a comprehensive study that maps whether this is in fact the case. But if there is an AI program that stands as a barrier between them and the then incarceration, that program can insist that these 3-4 inputs come from the state. And those 3-4 inputs can be, they have to be figured out what they can be. But it'll really be, I think, one solid way of ensuring that the grant of bail is the default norm. And you can't get around it just because your judge is politically inclined in one way. So maybe, I don't know.
But on that, you know, like even procedural matters need to have some aspect of due process and natural justice. So would you say that those criteria, like those 2, 3 or whatever categories, would they involve the application of natural justice? And if they do, how does an AI even measure that? Isn't that something that a human has to do necessarily?
So the model that I'm imagining is it won't require any natural justice because the default presumption is you are giving bail. So the state has to sort of try and give factors as to why bail should not be given. And those factors, instead of being natural justice, which is a defense that I will take to secure my liberty, they have to now give arguments about, oh, this guy is a particularly bad guy. He's going to run off. These are the 2 witnesses he has in fact threatened, stuff like that. So I think maybe there are some elements of judicial discretion that you want to reduce because you really want to protect liberty in a more robust way. So maybe, I don't know. I mean, if that partial sort of mechanism is possible.
I see that there is one challenge that is very particular to introducing AI as judges is the fact that it is a very important rule of natural justice or whatever you say, that there has to be some judicial application of mind, right? So you cannot really expect an AI to have the the right judicial application of mind.
Yeah,
and it does necessarily require human judges to sift through data, sift through the facts of the case and all of that, and then arrive at a particular conclusion rather than just deferring it to some AI model.
Yeah, that's very interesting. I agree with you. I think you may be able to take care of it by providing an effective review mechanism immediately by a judge in some cases. But yes, point taken. And I think the cases where your concern will be most worrying is where the state figures out a hack into the AI system. And if that happens, then, and if the review by a human being is rare and exceptional and all of that, which you would ideally want it to be, that will be a problem. So I don't know. I mean, I think we'll just have to see what model can come up for something like this before we decide.
This almost feels like the next comic by Marvel, where like the world is being run by AI and everyone is trying to hack it. Any other questions, anyone? Okay, I think I had a question, Shrutanjaya, and like this actually relates both in terms of like the data that's available in law and like, you know, the AI itself. Like, and this is more of an open question where I just want your opinion, like in that sense. So one, we know that, you know, data like the background of high court judges, that's something that's ought to be available, but is usually not. And I think like all of us here have been like, you know, trying to scavenge for all of that data and like put it all together, because that itself is like a, you know, very important picture to sort of like present in ourselves, like who are the judges who are like really, you know, like presiding over cases and like deciding for like the country, right? On the other hand, like for AI and everything else to machine learning to be effective, and I'm completely coming from the point where all of this is like assistive technology, like the ultimate decision still lies with like the judges or the lawyers, right? There again, like a very important piece which is missing, at least in Indian law context, is just the training data, right? Like what will I train my machine learning model on, right? Like in US, at least, like you have like these models available. I mean, like the challenge that I really see is that most of this training data building, most of this like AI building work needs to be done by people who actually has the expertise, and not even so much of technical expertise. I think like there has to be like some level of symbiosis between both the engineering side of things as well as like legal expertise side of things for any effective AI legal solution to sort of like come up, right? Like, but at the same time, we see these barriers in terms of like, you know, intimidation from both the sides, that like one, like the whole algorithm is like very intimidating. At the same time, like the law is very intimidating for people who don't know like one side of the story, right? Like how do you see some of these like, you know, conversations to begin? How do people like start participating in building AI for good more than anything else? I just wanted to hear your thoughts, and how does like legal fraternity sort of feels about it?
Yeah, I think the legal fraternity feels absolutely nothing about it. I don't think they think about these things at all. It's, I mean, I think the general, I don't know if this is your perception as well about the legal fraternity. I mean, I'm talking about the litigators, but my general sense is there's a strong resistance to any sort of AI intervention, because most of the folks feel that, oh no, AI means that judges are gone. AI means that very important decisions that you know, depend on subtle facts will now be taken by AI. So I don't think there is enough awareness about what AI, the various narrower possibilities that AI presents. So I don't think the legal fraternity will have a view on it. But yeah, I think I totally agree. It has to be a symbiotic project. How it will start is I mean, I don't know. It's you've caught me off guard on that. But I think, I mean, my first thought is this picking of data that you feed into a program is hardly a neutral exercise. So you can't, I mean, if you pick me for feeding bail data, for example, for that hypothetical nonsensical program I was talking about, I'm going to just pick up all the cases where bail was granted. And that's not because I'm trying to be biased, but because that's just my own subconscious bias, because I don't like. But so that's the point. I mean, if you pick 5 people who are going to be in charge of selecting the data that goes into the program, some part of that exercise is going to be value laden. And I don't know how you can escape that charge at any stage. You'll have to first figure out, okay, what are the various parameters on which people can be biased? Then on those various parameters, let's pick up people from both sides, something like that. Yeah. But what a challenge. I mean, I don't know how to escape that charge of bias. But conversations, I don't know, will have to be started by somebody like you, I suppose, who's doing who's doing data work. I mean, litigators don't care. Academics, I think only the younger ones, very few academics actually care about data. Doctrinal research has always been the fashion. So I think it's When I speak to my doctor friends and I tell them, in the law, we research doctrinally. What the hell is doctrinal research? And they say, because they don't know any of it. They only do empirical research, which is very meaningful. They come up with, they conduct experiments, come up with data, and tell us the efficacy of vaccines, for example. They don't do this philosophy about what is equality and what is not equality. So for them, it's very strange. But yeah, I think it'll have to be started by an organization like you. Maybe you can bring together litigators and academics and engineers, something like that. But I don't see it starting in litigation circles. I don't see it starting in academia either. I mean, unless something has drastically changed from the past 4 years or so.
Yeah. While we were saying, I was just thinking if doctors sort of like took their decisions with precedence, like I don't know how many of us would be like
something. Yeah.
But yeah, any last questions? We are near time, but like any last questions, any of you, any thoughts, any comments? Most welcome to unmute yourself and say it.
Yeah. I've mentioned in the chat also, but I thought I'll just say it out loud too. Since we're talking about AI in the justice system, and since we as a community are also shifting to more alternative modes of dispute resolution, it might be interesting to see, like a bot trying to mediate a case, or how could you possibly have AI-driven mechanisms in a very humanistic arbitration or mediation, where the entire purpose is that a person, like a third party, actually comes and tries and resolves that issue. So I think since we are also converting into that more different alternative type of resolution, it might be a challenge. But in that way, it might also be easier because the burden might be lessening. So there might be less cases. I don't know. I'm just,
Yeah, no, I think I'm not sure if I want to think about a model where there is no mediator, but I think I can see immense value in there being an AI system that sort of knows what the law is on a particular area. For example, if suppose there is a legal dispute about some property between you and me, and we are trying to mediate it, that program can tell us, look, Smita is obviously the winner when it comes to the law. So you're not, so then I know what they call BATNA and VATNA in negotiation are, that I know what my worst alternative and my best alternatives are. Hopefully it won't be, we won't be doing it together, because then it will be embarrassing for me to know that I don't have any chances. But yeah, I think it's quite interesting to think that legal outcomes can be predicted sometimes because it's quite mathematical. Some of the doctrines that courts have laid down are really quite mathematical. A plus B is C, simple. It's nothing more than that. So in those cases, yes, I think so. But in cases like, and I don't know, maintenance calculation in a matrimonial matter. Okay, what is the husband's income, wife's income? How much assets do you have? Just input all of that. Like the Saral form on the income tax website. So you just input all of this information and maybe
even in like limitation cases, it might be interesting to see.
Yeah. The only thing is judges love condoning delay in the country.
That's true. But then that's what, right? Like when you were saying that, I was thinking that even in maintenance cases, they might be biased to either party based on some subjective history that the data cannot possibly capture. For that, what might be beneficial is that this mechanism can just give them the raw data. There is no harm in having that raw data and then a human trying to interpret it and analyzing it, like what you do with your judgments, like the examples that you gave us, right? You had that raw data, you gave it to a judge, and he or she decided whether it was admissible, whether it had any merit. So that way, it might be beneficial to have some sort of raw data.
Yeah, I agree. I think the one possible problem that AI could also solve, or technology, I don't know if AI is necessarily involved, can solve, is that often the husband, but sometimes also the wife, lies about their income in court. And they say, oh, I don't have any. So at that point, the judge spends some time saying, okay, where is your passbook? Get your bank. And the wife comes and says, no, it's not just SBI. He also has an account in HDFC. And then that comes up. So all of this, I think, maybe it will save a lot of time if at the first instance you could ask, the husband to produce all of this.
What might also be interesting is now that everything is connected to Aadhaar, what if when you're filing a case, you have to furnish those details and it's already like fed into their system? Damn, that would be cool.
That now it's borderline scary. So
yeah. Fascinating stuff. Just last one thing, I'm going to put a few links on the Discord channel and forum where we recently had this online dispute resolution week of sorts, where we invited a lot of like online dispute resolution providers from around the world to speak about like their products and their experiences. Surprisingly, there's an organization based out of Brazil which does like fantastic work in like online dispute resolution, and they're at least like not even claim, like we know it with certain level of confidence that a huge percentage, and when I say huge, like north of 80% of their cases, they are able to get it resolved, or 80% of the disputes that they receive, they are able to resolve it absolutely automatically. So some magic happens behind the behind the computers, and like that happens. So I'm gonna put a few videos from that, like for all of us to see. Other than that, I think there was this entire series of conversation that Stanford sort of like did as part of their Codex lab, which I think is another great resource for any of you who are interested in understanding more about like how AI, sort of like would disrupt the whole field for both good and the bad. And I think like better be prepared than anything else. So yeah, any last comments, Shrutanjaya, like that you have?
No, I think there's been a fulfilling conversation. So I think we'll just all it's already 6:13, so I think everybody must be tired.
Yeah, I don't know if everybody is tired. I can just imagine like all of them thinking कि अभी 6 हो गया है, चलते हैं घर, नहीं तो और conversation करेंगे. But it was lovely speaking to you, Shrutanjaya. I thoroughly enjoyed the conversation, as I presume like all of us did. And yeah, I mean, all of us are engaged, and we are almost like nearing the end of Summer of Data in some sense. All of the participants were engaged in building this data set on the High Court judges and their background. Really important subject to bring transparency in that space. So yeah, we hope to keep on engaging with you, like for lovely conversations like this in future. Yeah.
Okay, thanks a lot for having me. I thoroughly enjoyed it as well, especially the questions from everybody.
Lovely. Chalo. Take care, everyone. Have a good evening and a great weekend. Take care. Bye.
Okay, bye.